Okay, I'm going live then.
Yeah.
Hello, everyone. Good evening to this session. This is by LiveLaw Academy today as part of a new course that we're launching. Today, we have with us Advocate Vrinda Bhandari. She is an alumni of NLSIU Bangalore and has done her master's in public policy and law from the University of Oxford. She's also a Rhodes Scholar. We're grateful to have you today with us, ma'am. The course that we're launching from LiveLaw Academy is a certificate course on the privacy and data protection laws in India. Over the course of 5 Saturdays from 10:30 a.m. to 12:30 p.m., we'll be discussing the various nuances of these laws with Advocate Vrinda Bhandari. So as part of today's discussion, we'll be discussing the recent judgment of the Bombay High Court in Kunal Kamra versus Union of India. So just to start off quickly, ma'am, if you can tell us something about the history of this case and the background.
Yeah. Hi, everybody. Welcome. We are doing a live where I can't see the people there. Yeah, so maybe just starting out from the case, I'll sort of go into just the history of the intermediary rule. So the IT Act or the Information Technology Act was enacted in 2000. Section 79 is a provision that provides safe harbor to intermediaries. So this is basically giving them immunity from prosecution, subject to them fulfilling certain conditions of due diligence, etc. In 2011, under its rulemaking powers, the government promulgated the 2011 Information Technology Intermediary Guideline Rules. Now, these rules were challenged in the famous judgment of Shreya Singhal, where the court read down Section 79 of the IT Act and the rules to say that an intermediary is only supposed to expeditiously take down content if it receives actual knowledge of the content being illegal, either from a court order or if it receives a formal notification by an appropriate government or an agency. Now, these rules were replaced in 2021 by the IT rules of 2021, which have made significant changes and have gone beyond the Shreya Singhal mandate. Now, challenges were filed to the IT rules across various high courts, etc. While these challenges were pending, there was a stay. Some of you may know Part 2 dealt with intermediaries. Part 3 introduced the new laws in terms of regulating, online news publishers and online content providers. Now, the court had directed a stay of certain rules in various high court proceedings, and the case was pending before the Supreme Court. And during this period, the government promulgated the 2022 IT rules. Then in 2023, they made a further change. They further made an amendment to the 2021 rules, and that is the subject of the Kunal Kamra petition in the Bombay High Court. Now, these rules, and specifically Rule 3(1) subclause B, subclause 5, basically very simply said that any intermediary, whether it's a social media intermediary or your Facebook or WhatsApp or Twitter, Google, all of those intermediaries shall observe due diligence, whereas it shall inform all its users and it shall make reasonable efforts by itself and to cause its users to not host or display any content in respect of the business of the central government, which is identified as fake, false, or misleading by such fact-check unit of the central government as may be specified. So very simply, what it required was that an intermediary shall make reasonable efforts by itself to not and to cause its users to not host any information in respect of any business of the central government that has been identified as fake, false, or misleading by a fact-checking unit, which I will call FCU, which is notified by the government. That is all that is there in the rule. We don't know, the rule doesn't define what is fake, false, or misleading. The rule doesn't explain how a fact-checking unit will be constituted, who will be part of the fact-checking unit, how will it function, what is the need for a fact-checking unit as well. So these petitions were then challenged in the Bombay High Court by a bunch of petitioners. So the first was Kunal Kamra, who many of you will obviously know. Then there was the Editors Guild of India. There was the All India Magazines Association. So there was the National Broadcasters Digital Rights Association, so the NBDSA. So various media houses filed challenges before the Bombay High Court, and the court passed a common order last month, where we got two separate opinions. So we got two conflicting opinions. There was an opinion by Justice Gole, and there was an opinion by Justice Gautam Patel. So Justice Patel struck down the rule as being unconstitutional, and Justice Patel upheld the rule, very simply. which meant that it is now gone before a third judge of the Bombay High Court, who is now going to decide on the validity of the rule. And then depending on which way he rules, we will see whether the rule is upheld or the rule is, or the rule has been struck down. Another kind of development, and we can speak about this later, Parvati, or right now, depending on whatever you think or whatever the audience wants, is what happened after this. Now, during the pendency of these proceedings, the government had given an undertaking, like a statement, where they said, we will not notify any fact-checking unit till the till the pendency of this petition, very broadly, colloquially speaking. Now, that undertaking extended till the time of the orders passed by Justice Patel and Justice Gole. The question then became, when there is a conflict, so these orders were passed on 31st January. Now, when there is a conflict between two judges, and it's gone to a third judge, what happens to this interim statement? Can the government constitute a fact-checking unit right now? Or, will a judge have to decide that? So these issues now went before the same third judge, who after a detailed hearing yesterday, pronounced that the government's statement does not have to be. So the government said, now we want to withdraw the statement. We don't want to give this undertaking anymore. So we think that the fact-checking unit should be constituted. So this was argued, a huge argument on interim, etc. And yesterday the court ruled that your argument on interim application, the third judge said, your application on interim is rejected. So the government's statement, in some senses, will not continue, which means now there is freedom for the government to notify the fact-check unit as well. So this is sort of, I would say, the history of what has happened in the Bombay High Court. And then subject to, what you think, Parvati, we can go, to Justice Gokhle's opinion first and Justice Patel's opinion second.
Can you tell us something about like the rationale of why there was such a split judgment, of what was the rationale behind each judge's opinion?
Yeah, we'll go to that. Is there any preliminary question that anybody has right now on any of the things?
There are no questions so far, but to the viewers, if there are any questions, please put them on the chat box. We'll take them in the end. Or
yeah, so if anybody has any questions, then please sort of let us know. The third judge, incidentally, since I've not named his, is Justice Chandurkar. So he's the third judge who's deciding the issue. So yeah, we'll come then first straight away to Justice Gokhle's opinion. She upholds the rule. Now she gives she analyzes her judgments and raises 6 questions. First, she said, is the rule ultra vires, Section 79 of the IT Act, because it authorizes automatic deprivation of safe harbor for intermediaries, and hence does it go beyond Article 19(2) of the Constitution? Her second question is, does the rule violate Article 14? Because the petitioner's argument was, it was making the central government an arbiter in its own case, because it was requiring the intermediaries to act pursuant to the government's identification of information that is fake, false, or misleading. Now, whether this loss of safe harbor for intermediaries has a direct chilling effect on the free speech of users, and is that a ground to set it aside? The fourth question was, are the terms fake, false, and misleading and the business of the government, are they overbroad? Are they vague? Are they effectively arbitrary? The fifth question was, does the rule fail the test of proportionality? And whether it addresses competing interests of an individual on one hand and the interests of the state on the other. And the final question is there a direct nexus between the rule and the mischief that it seeks to address? Now, coming to the first question, she answers all the questions in the negative. In respect to the first question, she makes 1 or 2 important determinations. One, she says that the fact-checking unit, which would represent various government departments, ministries, etc., is a user in and of itself. So if this FCU, just like you or me are users of, we see some content on Twitter or we see some content on Instagram, just as we can report any content, the FCU is also simply a user, and that can report any complaint, any content, and say, look, that content is fake, false, or misleading. And that is and her entire opinion is predicated on a text, on a reading of, so both judges go on to this literal reading of Rule 31B5, and her entire reading is predicated on this argument that you have to knowingly and intentionally communicate this fake, false, or misleading information. So she said, because there is this knowledge, there is this requirement of knowing and intentionally communicating, it means the intermediary has to make no additional effort. So the moment an FCU reports it, just like if you and I report a content, the intermediary is then free to sort of decide on that complaint. So just because an FCU reports it doesn't mean there is an automatic takedown. So that's sort of her first reason. And she says because they can either choose to take down the content, or if they don't want to take it down, they can also just simply add a disclaimer. If they add a disclaimer, then that is sufficient. Incidentally, Justice Patel said, look, there is no requirement of disclaimer in the law. There is no question of the disclaimer being allowed in the law. So how can you say it is a disclaimer when you have to say, not to host? And then finally, on the first question, she said these IT rules complement the blocking rules, and there's no automatic safe harbor deprivation. So the rules are not ultra vires. On her second question, she said that the FCU is only tasked with identifying information which is related to government business that is shared by the intermediary. So it's not that the intermediary will lose safe harbor for any reason. It only loses safe harbor, or say, Google or somebody will only lose safe harbor if, one, it fails to make reasonable efforts to rectify the situation once something has been reported, and if the offensive information is intentionally communicated to the user, knowing that it is fake, false, or misleading. So she's saying the FCU does not have direct powers. The FCU cannot issue an order saying take down this information. They can only report it. And if the government chooses, if the intermediary chooses, then if it then fails to make reasonable efforts to rectify it, and if this information is communicated knowingly to the user, knowing that it is false, fake, or misleading, only then it loses safe harbor. And then there was a whole question of, does the FCU represent the views of the government, and is there this bias that is inherent? And she said that just because the persons comprising the FCU are appointed by the government and that they will have knowledge about the working of the government does not mean they're biased. So there is no challenge on arbitrariness. That was rejected. This sort of doesn't really answer the question of, what happens in a practical manner if an FCU identifies some information as fake, and an intermediary doesn't act on it. Does it mean that they failed to take reasonable efforts? So that sort of is not dealt with in the opinion. Then Justice Gole rejects the challenge on chilling effect because she says that there's no direct implication on an intermediary. They are not directly penalized, right? It's not like safe harbor is immediately lost. What it only means is, in a particular case, there will be a determination by the court of whether they will then be prosecuted under the law, subsequent to the loss of safe harbor. They are also always free to challenge the FCU's determination of something being fake, false, or misleading. So it's not like they don't have any remedies. And the fact is that because there is a requirement of knowledge and intent, so then political satire is not covered, because political satire, that it's not like you're maliciously trying to communicate it. Political satire is understood as being satire. So she says for all these reasons, there is actually no chilling effect. There was also a huge reliance on the fact that no intermediary had directly challenged this. And this is one of the government's arguments as well, because the government said, look, we have come into this rule with a lot of consultation with the intermediaries. And that's the reason why no intermediary has challenged it. And so she relies on that, who are these people who have challenged the rule? None of your intermediaries. So why are you complaining? So that's sort of, the point on chilling effect. On the fourth question, saying that, are the terms fake, false, or misleading and business overbroad? She says no. She says fake is just something which is non-existent. So, there's no question of subjective interpretation. False information is not in per se offensive. It is only when the intermediary fails to make some reasonable efforts that it becomes false. And she says these are all dictionary terms. These are best understood. Now, interestingly, she doesn't go into misleading. The term misleading is actually not discussed in the, the term misleading is not discussed in her opinion. Now, and then finally, on the last two questions, he said, look, there is a real problem of deep fakes and there's no right to share information, etc., which a person knows to be false. So it's not like, you have a right to say falsehoods. So she relies on that as well a lot. And then she says, look, platforms have to be held accountable for any disruptive speech or hate speech. So she says there's a lot of problems of hate speech that abide today, that are abound. And so we have to deal with it. So this FCU is a good method to deal with it. And it will help the government curb this menace of fake, false, or misleading. So she said there's no, the way the petitioners are pitching it, that this is a battle for the control of the, digital content, is absolutely not true. And the fact that it could be misused is not a ground to strike it down. And hence, in a very simple way, she, in the simple way in the sense of the way I've described it simply, she basically then dismissed all the challenges. of the petitioners and upheld the rules. Should I then go?
Yes, go to the. I think one of the doubts I had hearing this was, so when we say what is the kind of penalization that we're looking at? I mean, once an FCU identifies an intermediary as having posted something that's against or is fake news for that matter, what is the penalization that the statute here imposes on them?
So that's the interesting point, right? Like that's actually a very practical problem about what happens in terms of Rule 7. So Rule 7 of the rule says you will lose safe harbor status if there is this determination that you have failed to apply due diligence efforts. Now, what that really means is, does it mean that the moment FCU notifies something, and if I don't act on it, do I immediately sort of lose my safe harbor status? Or, which is what the government, Justice Gokhale's view was, that there's no automatic deprivation. The FCU is only saying it. But what Justice Patel says, and what I kind of believe would happen in a realistic term, if the government identifies something as fake, false, or misleading, suppose I say, no, I don't agree with it. As a matter of practice, no intermediary is going to contest every single determination of fake, false, or misleading. So they are actually going to agree, they are just going to take it down because that's the easier path. Because if they don't, technically, they could at least be held to have been violating Rule 31B5 because they will say, despite knowing that despite me telling you that this information is false, you have not taken it down. Hence, you have not done reasonable effort. See, if I know that something is fake, I mean, if I'm told that something is fake and I don't take it down, have I complied with the reasonable effort standard? So the penalization would happen that Rule 7 says that if you don't comply with any provision of this rule, you lose safe harbor. Once I lose safe harbor, that means I become responsible for the content. So if there is some hate speech that is posted on Twitter, today Twitter is not liable for that content of the hate speech. Only the person making the speech is liable. Because Twitter is an intermediary. Once it loses safe harbor status, it then becomes responsible for that particular content. Now, there is another very interesting question which is undecided, where the issue is, do I lose safe harbor for all cases, or do I only lose a specific limited safe harbor for that one case? This has not been decided by the court. My view is, obviously, if you lose safe harbor, it's not like you lose your safe harbor in everything. You would only lose that safe harbor in that particular instance.
Yes.
Yeah, so that
in some senses, there's still a lot of vagueness as when it comes to the penalties and exactly what the ambit of the limitation of the safe harbor would be.
Yeah, and the point is, none of this, we don't expect any of this to actually in practice be regulated, to be litigated, because for an intermediary to come to court and to challenge a fake, false, or misleading notification is very going to be expensive, right? You're not going to challenge hundreds of things that are tagged as fake, false, or misleading. B, why would, beyond the point, it's not their speech, right? And so as a private corporation, it's anyway easier for an intermediary to say, look, I mean, we tried, but we have to now follow the law. The incentive then becomes on the user, the person whose original content it was to challenge it, which again then has a huge access to justice issue. Yes. So yeah, that's how I think it would work.
I think now we should maybe talk about Justice Patel's opinion and
since we're I will just go to that. Yeah, so now Justice Patel's opinion, so he strikes down everything. He says that the 2023 amendment violates 14, 19(1)A, 19(2), 19(1)G, so which means 19(2), 96 of the Constitution. And it's violative of principles of natural justice, and it's ultra vires, Section 79. And he says that, look, the rule is actually taking a form of censorship of user content, which goes beyond 19(2). Now, one of the things that I've not spoken about, which is an important thing for us to consider, is what was the need for this rule? Today, the government does have a fact-checking unit in some senses, which is the PTI, right? The Press Trust of India. They are very regular. They have very active Twitter presence as well. And they are, they basically do end up catching news that is fake, false, or misleading. So one of the questions was like, why is it that we even need these rules in the first place? So Justice Patel also takes that into consideration. His main, the premise of his judgment is that, look, the rule creates two classes of information with respect to which due diligence will apply. First is the information which relates to anything other than the business of the central government. So this could be some post of mine with respect to, a concert that I went for today. Now, this is information that has nothing to do with the business of the government. So there is no FCU in this case. There is no question of knowledge. There is no question of intention. And hence, a separate standard will apply because you don't have an FCU first and because knowledge and intention is necessary. So now the whole distinction between Justice Patel's opinion and Justice Gokhale's opinion is, Justice Gokhale says that a prerequisite for this impugned rule to apply is that an intermediary must intentionally communicate this information with the user, which it knows to be fake, false, or misleading. Justice Patel says this is a wrong statutory interpretation of the rule. I won't go into that in a live because it's very difficult without the text here. But both of them basically interpret Rule 31B5 very differently. And Justice Patel, on a basis of, again, a textual reading of the rule, says that knowledge or intention is not a prerequisite. So he says, if you have then information that relates to any business of the government, there are two separate distinctions. One, you have to have an FCU. And B, even if there is no knowledge or intention of that information can be classified as fake, false, or misleading. So because of this, he says you're creating two separate categories of cases. And in the business of central government issue, the focus then becomes on the intermediary. In the first case, it is Vrinda Bhandari. Do I know that something is false and I'm posting it intentionally, right? In that case, I get covered under the standard rules without this fact checking in it. The second is, does the intermediary know that something is fake, so false? So the question is on whom is, in some senses, the burden lying. In a normal case, if I today go and say that there are riots happening outside, which I know to be false, then the burden is lying on me, right? But in the second case, if it relates to the business of the central government, then the onus shifts on the intermediary, because then the intermediary has to decide whether it is permitting the continuance of information of my post, for instance, or what the FCU has determined to be fake, false, or misleading. Now, so for instance, in the same riot example, if the FCU says, this information is fake, but actually there was a riot happening. Suppose I say there is a riot happening, there is actually a riot happening, and the FCU says no riot is happening. Then the FCU has determined that my content is fake, false, or misleading. So then the onus sort of falls on the intermediary to then decide whether it is permitting the continuance of this information. There is no way for the intermediary to directly assess anything. So the burden shifts, and he's saying what you're effectively doing is that the rule is shifting the responsibility of content accuracy from the creator of content, so from me, to the intermediary, right? Which actually has no control over the content. Twitter does not know whether a riot is happening, right? It's only me, or, in my post, that I would know whether what I'm saying is true or not. And he's saying that in such a case, it is only the FCU, which is the sole authority, that can decide whether a piece of information relating to this business of the central government is or is not fake, false, or misleading. He also said, look, what are the meanings of these terms? All these terms are vague. What is business of the central government? What does that mean? Really, in a real term, is it like budgets? Is it elections? Is it a government program? Is it, what is happening at a local level? Like, what does it mean to say business of central government? And he's like, in practical terms, how will the FCU actually function? And so he says the amendment has a chilling effect. It's overbroad. It results in sanctioning the government through the FCU to be the final arbiter of what is fake, false, or misleading. And hence, it kills any right to have an opposing point of view. And he's saying there is no reason to have this two classifications within the statute, where you're saying that information that relates to business of government receives a high value protection. And so he said, look, the government cannot be the final arbiter of this. He also said that as a matter of practice, the moment that any content gets flagged as false, for instance, an intermediary will have no choice, and that goes back to your question, Parvati, it must not permit the content to be hosted, because otherwise Rule 7 applies, and they will say you have not conducted due diligence requirements, and hence you will lose safe harbor. And there is nothing in the amendment that suggests that the intermediary actually has a choice to conduct an inquiry relating to the information flagged. So is it that the FCU is just telling me, look, you decide? But the text does not give me that right to decide, according to Justice Patel. And so he says that, look, on the importance, safe harbor is a very important provision. It's an intermediary. It recognizes it's a free speech right. It removes the potentiality of indirect censorship. So he also goes into that in a fair amount of detail. He also says that, look, in terms of, as a matter of practice here, the fact that you have some post-removal grievance mechanism is completely inadequate, because my free speech right is affected at the first instance. So he's saying that's not fair. The metric to judge the rule is only what the state can do or cannot do. And it is not what the government wants it to do. So that's how you have to check it. Then he says these terms, fake, false, misleading, they're all extremely vague. Indian law, has always recognized that things are not fixed, right? The Evidence Act, for instance, has the idea of, preponderance of probability, this idea of prudence. And, law in India recognizes that there is not an absolute determinism on everything. And so he says that you cannot, as a matter of fact, everything cannot be absolutely determinate, that it's fake or not, it's false or not, and especially if it's misleading or not. Because misleading is really it's a very vague term. What does it mean really? And he also says that this is a huge part of his opinion, that the government should not be the sole repository of deciding what is misleading. And he also, in that respect, says a disclaimer will not work. Finally, the government had argued that all of this was in public interest, because of this proliferation of AI and misinformation. And he says public interest, national security are not grounds under 19.2, and hence, struck it down as well on those grounds. And then in terms of practical concerns of how the FCU will function, he says there are no safeguards in the rules against bias. There are no guidelines on how the FCU will function. There is no procedure for hearing that is provided. There is no opportunity that is provided to either an intermediary or a user to counter the case that the information is fake, false, or misleading. There is no requirement of a reasoned order. And the government is basically deciding its own cause. And so it fails all those tests, and it creates substantive law, and hence it fails even the ultra vires test. So this is the broad gist of the case.
So now, what is the status quo? I mean, you said that it's now pending before a single judge there.
Yes. So the status quo is that the main matter has to be decided by the single judge, and he's going to give a set of dates. On the interim, the division bench today, now the 3-judge opinion, the opinion in the majority in the Bombay High Court would be that the interim protection that the FCU will not be constituted during the pendency of this petition has gone. So in reality, this means that the FCU can be constituted at any point of time. So it is likely that, everybody will move to Supreme Court, and there will be a requirement for the Supreme Court to determine this.
So with your experience in all of the cases like Aadhaar and Pegasus and everything, personally, how do you think this rules and the judgment would impact A, the citizens, and B, the intermediaries that are currently working in India?
Yeah, so I'm obviously biased in this and in a sense conflicted to answer this question because I was part of the proceedings in the Bombay High Court. So I have been involved in this case even as a lawyer for one of the petitioners. But so obviously, from that, take that with a pinch of salt. But I obviously do think this amendment goes very far in creating a chilling effect and in having a fact-checking unit and having something that is going to be decided by the government and deciding what is fake, false, or misleading. Like the very idea of having a fact-checking unit to me sounds very, it calls back to like the Soviet days, right? Like, why should you have this one central government unit deciding what is fake, what is false, and what is, to me, misleading is just such a term, a vague term. Like anything can be, it could be true, but misleading as well, right? Like if it's presented in a particular way, it could be misleading. Like who is to decide that? And you're leaving it only to the government to decide. To me, that's a real big problem in terms of, the chilling effect that it's going to have. Like you need to only take action once or twice so people to start self-censoring. And like, as I mentioned earlier, the commercial interest for private corporations to challenge everything just does not exist. To challenge every notification and to challenge every flagging of content as fake, false, or misleading. Parvati? Parvati, are you stuck? Or have I lost signal? Okay, I feel maybe we've lost Parvati.
I'm terribly sorry. I think we had a small power issue here. I hope I'm still audible.
Yes, you are.
Yes. Yeah. So I think I agree with you on that, and I also think that the aspect of what constitutes center's business, as you said, what would be a business for the center, and that being misleading. Also, I think there's a sense of vagueness in that as well. I don't see any questions in the chat box so far, but I think we have a lot of viewers. So if there are any questions, I think you can reach out to me. I think my ID is there with this live. So if there are any questions, you can ask them, and we'll be addressing that, I think, later on. Just to conclude the talk, I think I would just like to again say that we'll be having a course from LiveLaw Academy, and Vrinda will be teaching us over a course of 5 Saturdays. We're very excited for this course. It's starting the coming Saturday from 10:30 a.m. to 12:30 p.m. We've kept the timing so that I think the working professionals, the students, everybody can accommodate it during their Saturdays. So you can register for this course. The link for it is there in our description to this video itself. But thank you so much for your time. Had a wonderful discussion, and I hope the viewers had a good time as well. Thank you very much.